Now I am going to dictate a legal passage at the rate of 100 words per minute on latest Supreme Court judgment. 5, 4, 3, 2, 1, start. Let's start. While dealing with a claim petition in terms of Section 166 of the Motor Vehicles Act 1988, a tribunal stricto sensu is not bound by the pleadings of the parties, its function being to determine the amount of fair compensation in the event an accident has taken place by reason of negligence of the driver of a motor vehicle. It is true that occurrence of an accident having regard to the provisions contained in Section 166 of the Act is a sine qua non for entertaining a claim petition, but that would not mean that despite evidence to the effect that death of the claimant's predecessor had taken place by reason of an accident caused by a motor vehicle, the same would be ignored only on the basis of a postmortem report. The deceased was a constable. Death took place near a police station. The post-mortem report clearly suggests that the deceased died of a brain injury. The place of accident is not far from the police station. It is therefore difficult to believe the story of the driver of the bus that he slept in the bus and in the morning found a dead body wrapped in a blanket. If the death of a constable has taken place earlier, it is wholly unlikely that his dead body in a small town like Dharampur would remain undetected throughout the night, particularly when it was lying at a bus stand and near a police station. The learned tribunal, in our opinion, has rightly proceeded on the basis that apparently there was absolutely no reason to falsely implicate the respondent numbers 2 and 3. Claimant was not at the place of occurrence. She therefore might not be aware of the details as to how the accident took place, but the fact that the first information report had been lodged in relation to an accident could not have been ignored. Some discrepancies in the evidences of the claimant's witnesses might have occurred, but the core question before the tribunal and consequently before the High Court was as to whether the bus in question was involved in the accident or not. For the purpose of determining the said issue, the court was required to apply the principle underlying burden of proof in terms of the provisions of Section 106 of the Indian Evidence Act as to whether a dead body wrapped in a blanket had been found at the spot at such an early hour, which was required to be proved by the respondent numbers 2 and 3. In a situation of this nature, the tribunal has rightly taken a holistic view of the matter. It was necessary to be borne in mind that strict proof of an accident caused by a particular bus in a particular manner may not be possible to be done by the claimants. The claimants were merely to establish their case on the touchstone of preponderance of probability. The standard of proof beyond reasonable doubt could not have been applied. Stop. Thank you.